State of Idaho versus John Jr. Demaria, who's here today with Counsel Gustavus and Miss Allen for the state. We're calendared for sentencing. Are we proceeding today?
Yes, sir.
All right. Very good. The court has reviewed the pre-sentence report and accompanying materials. Have you had that opportunity?
Yes, I have, Your Honor.
And as you went through those things, was there anything that you saw that needed clarification or correction?
Through the PSI, I found, I think it was 2 discrepancies that were misquotes in there. I can address them in argument, Your Honor.
Okay, very good. If that's the way, given the nature of those clarifications, you would like to approach it, then I would welcome that. As for the pre-sentence report generally, do you consent to the court considering it for purposes of sentencing today?
Yes, I do, Your Honor. And Your Honor, if I could, on Thursday, the defense filed a Mr. Demaria's personal statement, and it's called Defendant's Exhibit for Sentencing. It was a handwritten letter to the court.
Okay. Yes, and the court did review that on Friday.
I would ask that that letter be sealed and attached as an addendum or attachment to the PSI.
As a part of the
Yes.
PSI. Okay, and it could have been submitted in that form, and so I approve that. Very good. Are there going to be any witnesses today by the defense?
Yes, Your Honor. The defense intends to call Jerry Taylor. She is a counselor for Mr. Demaria locally.
Very well, then I'll invite that to occur now. All right. That'd be great. Madam Clerk will place you under oath.
Do you solemnly swear that the testimony that you're about to give in this pending cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, ma'am, if you want to go ahead and have a seat in the witness chair. You may inquire.
Good morning. Can you please state and spell your last name for the record?
My name's Jerry Lynn Taylor, Taylor.
And how are you employed?
I'm a licensed professional counselor, therapist. My expertise is with addiction, so I'm also a advanced certified alcohol drug abuse counselor.
Okay, and where do you currently work?
Teton Counseling.
Okay, and how long have you worked for Teton Counseling?
I think 6 or 7 years, I'm not sure.
Okay, and did you do counseling prior to Teton Counseling?
Yeah, I worked for the Department of Corrections for 11 years.
And what did you do for Department of Corrections?
I did their groups and I was a case manager for them.
When you were did groups and case manager, was there any particular type of treatment that you focused on with those persons?
With the Department of Correction, it's always cognitive based. So I did cognitive self-change and the different drug and alcohol classes that they were offering at that time.
And did you do that for persons with like chemical addictions as well as like sex offender treatment?
We weren't eligible to take anybody with any type of sex offender because I worked here in Idaho Falls and we were right by a daycare. So it's only addiction.
Okay. All right, and
Or criminal. I forget to always criminal too. There were those.
so you have been involved with felons and treating
Yeah.
felons. And do you know Mr. Demaria?
Yes.
And how long have you known Mr. Demaria?
Probably 5 or 6 years.
Okay, and how long have you been giving Mr. Demaria treatment at Teton Counseling?
After his evaluation was completed and she recommended mental health counseling, that's when I started to see him.
So approximately a year or less?
Probably close to a year.
So you knew him as prior to treating him,
Right,
and how did you know him then?
at the gym.
All right. So what types of treatment have you been giving him in the past year?
We looked at his porn addiction and how that has affected him, and how he was raised and how that has affected him, and set him up for PTSD.
Okay. So would that be fair to say that you would call that trauma counseling?
Yes, sir.
And do you do that with group treatments or individuals?
Both. He's participated in 2 groups a week and 1 individual.
And during this treatment, is he engaged?
Yes.
Okay.
And he's honest in the beginning how he didn't think therapy would help, how this feeling thing is overrated, and the last time he was in group, people are heartfelt connected to him, and they'd fill the courtroom if he would have allowed it.
So his treatment began reluctant at first, kind of dragging him along like a donkey, but then progressing into active involvement
Yes, and encouraging other people.
and encouraging. And does he do any other like mentoring himself or peer counseling?
No. Just in the groups, but he's very supportive. Like he'll help get somebody there who don't have a ride, things like that.
And do you, as part of this, do you maintain records on counseling and attendance?
Yes.
Were you contacted by Department of Corrections for any of these records for the pre-sentence investigation?
No.
And what type of treatment in your profession would you recommend for Mr. Demaria?
He needs trauma treatment. And I'm staying in my lane, and that's what I can recommend, is trauma treatment. I've been trained in cognitive processing, and that's specific for PTSD and vets.
Thank you. No further questions.
Cross?
No, Your Honor.
All right, then, thank you. And the court doesn't have any questions, and so you may step down.
Thank you.
Very well. Are there going to be any other witnesses?
No, Your Honor.
All right, then how we will proceed is I will invite the state to make its sentencing recommendation, following which we'll invite the defense counsel. If there is rebuttal to be provided, then we'll permit that. And then lastly, Mr. Demaria, you may speak to the court if you wish as well, prior to the sentence.
Thank you, Your Honor. So today's case stemmed from a cyber tip that came into the ICAC unit back in May of 2022, and those cyber tips were coming into ICAC from May of 2022 through March of 2023. Synchronos is an electronic service provider that's associated typically with Verizon wireless users. So they typically provide the cloud account service for Verizon. There was a phone number in Ammon, Idaho that was linked to the defendant. There were several CSAM images, which is child sexual abuse material, being uploaded to a specific Synchronos account that was associated with the defendant's number. Ultimately, there was a search warrant that was conducted on Mr. Demaria's residence, and there were search and seizures of devices in Mr. Demaria's possession, and within that, specifically his cell phone, there were hundreds of CSAM images found. These were images ranging in age, but primarily of the ages around 10 to 11 years old, and they were all of minor female children. These images ranged from the females being in various stages of undress to poses in nude and lascivious posing, all the way to these female minors performing sex acts on male adults. So in this case, the defendant, the agreement reached between parties was that the state would agree the defendant could plead to counts 1 and 2. This would be a 3+7 imposed recommendation by the state, and for those counts to run concurrent. I am going to downward depart from that original recommendation today, and I'm going to recommend today a 2+8 imposed sentence, and for both of those sentences to run concurrently. From a review of the PSI and the PSE, we learn a lot about the defendant today. So we learned that he has no criminal history. He has a low LSI score of 11. He's been attending counseling every week since this arrest and this instant offense. He did have a rough upbringing as a child, and from my review of all of the documents and additionally with his letter to the court where he addressed the court, it's apparent that Mr. Demaria did not have a real significant supportive parental figure, at least in his childhood. He's a former Marine, and since being in the Marine Corps, he's been steadily employed. And it appears that he's even steadily employed to this day. There are several letters of support written in the PSI, or to the PSI. I didn't count how many there were, but I would guess probably around 10 to 12, if I had to estimate. And all of those are really good things, and they're certainly mitigating in the defendant's favor. But we also learn a lot of other things about the defendant through these documents. And one of those things is that the defendant is addicted to pornography, and he has been for quite some time. I want to focus on 5 main concerns that I really I want to highlight for the court that I gathered from both the PSI and the PSE. The first is that the PSE suggests that the defendant is low risk to offend on a child, on a human child. However, the defendant is placed as a moderate or high risk for accessing pornography in the future. However, this is not just talking about legal pornography. This also includes illegal pornography, which would include why we're here today, for CSAM. The second main concern that I saw is, if you look at the PSE on page 11, at the bottom of the second paragraph, the defendant admitted that since his arrest, he has fantasized about a 16-year-old client that he worked with and personally trained in the past. This is significant because it shows that there's an active interest, sexual interest, in minors, specifically female minors. The third that I'd like to highlight is that from the letter that the defendant wrote to the court, as well as within the PSI, it's obvious to the state that there's a lot of blame shifting going on. There wasn't a lot of accountability taken. So the defendant was blaming this instant offense on things other than himself. So things such as his father was the blame for his childhood. Then it moved into the Marine Corps, and the Marine Corps became the reason why he's engaging in this conduct. And then for later in life, after the Marine Corps, it's metal poisoning and health issues. But there's really not a lot of accountability that we're seeing in these documents collectively. The fourth is on page 13 of the PSE, where the defendant admitted that he would obtain non-nude online images of underage female models and then run the images through software that generated naked bodies of the clothed model. This is very, very noteworthy because we have someone that has such an addiction that they're needing to feed and take a further step to seek that need, that addiction, that craving for for CSAM, for these underage females that we're seeing in these photos. And the fifth and the last most concerning item that I'd like to point out is that on page 10 and page 13 of the PSE, the defendant admits that the reason he's looking for this content, this material, is because he became desensitized and bored with adult porn. And this is important because, and significant, because it's only going to continue. So right now, we know the defendant has an interest in 10 to 12-year-old female children, but what happens when there's a desensitivity to that age range? Maybe it continues to toddler age, and then maybe it continues to infant age. And then what comes after that? This goes directly to the factors that the court is required to consider when imposing a sentence. The first is the protection of society. We know from the review of the documents that the defendant has an active interest in minors, a sexual interest in minors. And we know that he has admitted to creating his own content to seek out that addiction. And this is why an imposed sentence is justified in this case, because we need to protect society, specifically from minor females. Rehabilitation. We know that the defendant, based on all of these documents, he needs intensive treatment. And Your Honor, the state does not believe that this treatment can be successful, and the defendant the state does not believe the defendant is ready for this treatment to occur in the community. Deterrence. The state is hopeful that if the court imposes a term of incarceration with the Department of Corrections, that this will not only deter the defendant from future conduct similar to this, but it will also deter others that are engaged in this same cycle. Not just possession, but perhaps those that are producing it, manufacturing it, and distributing it, when they see that this is happening to persons that are possessing this illegal content, it's going to deter others as well. And lastly is punishment. I've heard a lot of people say that CSAM is just pictures. There's no real victim. But I would argue that this is not true. Every time one of these videos or files is viewed again, that victim in the image is re-victimized over and over and over and over. And so punishment is warranted in this case, and the state feels that a 2+8 sentence is appropriate for this. We would ask the court to follow the recommendation today. Thank you.
Okay, thank you. Mr. Gustavus, the defense's recommendation.
Thank you, Your Honor. John is 45 years old. He is single. He has never had any children. A few years ago, he and a significant other were expecting a child. They lost that child prior to birth, so that's a bit, traumatizing for him. John had a very rough upbringing. John was very honest in his pre-sentence investigation as well as the evaluation with the doctor, Hatzenbuehler. He included a long description in the letter that he included with the pre-sentence report, but then also we would ask the court, to consider the letter he wrote to Your Honor. Overall, I want to help the court to explain one thing. Explanation for why we get to a point is not attempting to excuse it. I appreciate the state's understanding calling that blame shifting, but the point is, Mr. Demaria is learning to process and learning to deal with these things. And so by understanding that, he can explain it. That doesn't mean that he is trying to excuse what has happened. He is here taking responsibility. He accepted the plea agreement. He pled guilty. He knows why he is here. He is not disagreeing with that, and he is not saying that he does not need help. He recognizes that. Once released on pretrial services, which he has been on pretrial services for 1 year. Did the court see the update from pretrial regarding his behaviors and success on pretrial? I believe that was filed late Friday afternoon by Megan.
Yes.
He has complied with all of those terms of pretrial for a year. He complied with and completed the psychosexual evaluation. He got into treatment as soon as feasible and has been complying with that, with the treatment that he can get. The treatment that he's going to deals with addictions, and there obviously he has some addictions that are non-normal. He's not a person who has a problem with drug addiction. He's not a person that has alcohol addiction problems. He's got the porn addiction, which is as insidious as any of the others, but also still hard to deal with. They would not accept him into sex offender treatment locally because he was pending a psychosexual evaluation and because he was pending conviction in a case, pending sentencing. Were we dealing with a person who had a drug and alcohol treatment problem, they could have been in treatment for the past year and come before the court looking sober and clean and saying that I can abstain from substances, and the court could accept that. And they would look clean and healthy like Mr. Demaria looks right now. And so he has a different situation. He's got a different level of addictions that he's dealing with. And he is making efforts to do that. Today, in support of him for the court, he has his counselor, he has his mother, and he has one of his sisters here. They're here to support him. The court received a lot of support letters in the pre-sentence investigation that explain the things that he has been able to do for other people, even while he struggles with his own internal problems. If he could work with those internal problems and get those resolved, he could be a much better person for society. He can do treatment in the community. He has shown that he can do that for the past year. He has not had a cell phone that accesses the internet. He has to use a flip phone, and he has abided by those terms that the court has ordered. He has not had any contact. He hasn't had any contact with juveniles, and the restrictions placed on him through the court into pretrial services, where he doesn't go anywhere where children can be, which has restricted him for the past year from going to grocery stores, going to a lot of common places, which that in itself, it continues to be isolating for a person who has a history of isolating and internalizing the problems that he's had. And so it would be nice for him to be able to go out and actually be in the public and access things that would be healthy. He does have some hobbies of working out and of fishing, things that allow him to get out. But those are also solitary histories, solitary things that he's done. His LSI is an 11, which is low. And the things in there are, he has no criminal history prior to this. He has emotional and personal issues, which are some deep-seated insecurities and some history of trauma. His family is another one that popped up with that in the LSI, and that is extensively listed in the PSI and the letters, so I won't delve into that anymore here, Your Honor. But he has a lot of protective factors too, the things that the court consider. Can he be successful in the community? He has accommodations. He's maintained housing for years. He has steady employment. He's been employed for a year with Idaho Coatings. Prior to that, he was a personal trainer for many years. He was also a firefighter and some other jobs. So he's always been able to maintain employment. He has sobriety, he has social support, and he's got pro-social activities that he tries to do as much as he can. In order to, let's see, there's some other things that we want to talk about. He has been working on treatment since with Teton Counseling. He goes to a men's addictions class. Those work on addiction therapies, aversion technologies and things. Those are the things that that the court would, like if the court were to send him for treatment in the prison with either like a retained jurisdiction or with imposition. That's the type of treatments, one part of them that they would work on would be cognitive-based treatments. He also does groups on Sundays that deals with broken homes and trauma classes. He was on pretrial services for he was in jail for 15 days before going on pretrial services. He has credit for time served of 15 days. There were a couple of statements in the PSI that we wanted to address. One of which was in the PSI. It says that he's too old to go to bars. What he had said was that he doesn't go to bars anymore. That's not his thing. He doesn't drink. It's not the social atmosphere that he enjoys, even before being arrested. And the fantasizing about minors that the state pointed out in the PSI was prior behaviors that were asked rather than active behaviors. There was a recommendation for a neurological evaluation, which follows partly the metal poisoning that he dealt with, as well as just personal issues. The PSE stated that he had potentially a below average intelligence rating because he has issues with cognitive thinking through things, so addressing thought patterns, Your Honor. The metal poisoning caused a lot of issues with him, and having a potentially terminal disease puts a real damper and a depressive effect on people, and that can lead them into a different, a pit, kind of a bottomless pit that can be difficult to get out of. And quite frankly, Your Honor, at the time that he was arrested, he was kind of spiraling, and had he not been caught, he might not be here today. He was very depressed. So, for him, actually being caught was a positive thing. It has put a stop to the behaviors. It's given him an opportunity to reset, to engage with treatment, and show that he can be a good, positive member of society. It could be easy to send him to prison, Your Honor. He's trained by the military, and he'll probably be a model citizen if that's what happens, because the military trains people very much like the prisons do. When to get up, when to go to bed, when to eat, where to be at all particular times. And he can do that. He did that for years as a Marine. But is that what needs to happen at this point? We recognize the factors that the state listed out, the two health factors of protecting society. We do need to protect society from this type of issues. And he acknowledges that he did wrong. We need to work and look at rehabilitation, and he's been working as much of rehabilitation as he can the last year. If he could have got into sex offender treatment, he would have been actively participating, but they wouldn't accept him based on the status. Deterring the public, we understand. We've got the news here today to take notes, and there does need to be an issue of punishment, and he understands that. But, Your Honor, for a judge to consider whether probation is appropriate, you must have a good faith, abiding belief of success. And for the past year, Mr. Demaria has shown the court that he can comply with pretrial services, he can comply with restrictions, and he can do treatment. So at this point, we believe he's safe to be in the community, and he can do treatment in the community. So we would ask the court to consider a sentence of 1.5 years fixed with 3.5 years indeterminate for a total of 5 years on both cases, concurrent. And we would ask the court first to consider probation. He's shown that he can do all the things that the court would require. Now we understand that punishment is important, but what are we trying to accomplish with that punishment, Your Honor? Alternatively, should the court not consider him safe at this point to be in the community, we would ask the court to consider a retained jurisdiction to allow him to begin the sex offender treatment. Obviously, he wouldn't be able to complete that sex offender treatment within that amount of time, but that can be the jump start that the retained jurisdiction begins, and then he can complete that in the community once he has done that amount of time. Thank you, Your Honor.
Your Honor.
Yes, let's, let me just return to the state to see if there's any comments that the state wants to rebut in any way.
I don't think I do, Your Honor.
Okay, very well, thank you. Then, sir, you may take this opportunity if you're interested in making a statement.
First and foremost, Your Honor, I wish to apologize to you, especially the community, to have to stand here before you. I do take responsibility. I've had a lot of things in my life spiral out of control. I developed a lot of codependencies that were unhealthy, where a lot of people would not understand that. No different than with alcoholics or individuals who use drugs. Porn became my drug, and it's been there throughout all my statements. It was my go-to. As my attorney stated, if I wouldn't have been arrested, I was pretty close to ending it. So I'm actually very thankful. And so far I'm thankful for my counselor, and it brought me closer back to my family. So I'm not a monster, Your Honor. I'm a guy that had problems and I didn't handle them correctly. I've reached out a few times. Unfortunately, the VA has dropped the ball quite a few times, and this isn't me shifting blame. I have tried to reach out for help in many different instances, and it wasn't there. And so I always reverted back to what I knew and what would help me make it to the next day. And I know it wasn't right. I understand that I do have victims, and I want to apologize to the community for making them feel unease. I've lost a lot in this situation so far, but I do know that I've gained so much more from this.
Thank you for your statement. Are you fully satisfied with the representation of your counsel?
Absolutely, Your Honor.
Counsel, is there any legal reason why the court should not proceed?
There was not, Your Honor.
Well, thank you to counsel for your recommendations, and to the defendant for his remarks, the witness for her insight into treatment that has been engaged with the defendant. There are a number of things that I hope to share in response to the recommendations that I've heard today. First, let me acknowledge that this sentence that the court will impose does satisfy those 4 objectives of criminal punishment, and let me state those for the record. They include protection of society, deterrence to you and to others, rehabilitation, and punishment for the wrongdoing. And all of these are critically important and part of the court's analysis when fashioning a sentence. I've taken a number of notes and want to return to them and share my reaction to a number of the things that I've heard today. The first place to begin, I think, is an acknowledgement on the distance in which you've come over this challenge that you have experienced. And I suspect that is the very reason why the state has modified its plea agreement recommendation to their oral argument today, because there are a number of things that should be acknowledged. And I will share with you those things that I note. First is the presence of family members that are here today. I watched very carefully their reaction to your statements, and I think they were meaningful to them. Because of your actions, you've harmed others, you've harmed them, and it's been a difficult thing, but I am happy that they are here to stand by your side. Everyone needs that kind of support in their life, particularly as you confront these demons that have possessed you for some time. And it's important to highlight the fact that there have been a number of other individuals that have written letters on your behalf, and the court carefully went through those. I note that you have been actively engaged while you have awaited sentencing today, and there's a number of things that the court would comment upon regarding the treatment and the addiction that you have been addressing. I'll come back to that in just a moment. A very strong mitigating factor is that there is no prior criminal history. You have been employed, and it's interesting to hear you, through counsel, acknowledge that it's been a good thing in your own comments to have been caught and now to be held accountable. The use of the word spiraling, I'm not sure exactly what that means. I think there are perhaps a number of interpretations that one could suggest if that's the direction you were going, spiraling. I can say this very confidently, and it is a good thing that you were in fact caught, both for you individually and your own welfare, and also it is good for the community at large that you were caught. You have apologized, and I accept the sincerity that you have done that with. And as I said earlier, I believe that you have come a long way, and that's consistent, I think, with what the witness testified regarding initially how you presented, and there is an awakening. But I want to do now is to turn to a number of your own statements that I found both relevant and supported in the court's own experience, and why it's so critical that these are highlighted when pronouncing a sentence in a situation like this. And the first is, you acknowledge this addiction, that there is a pornography addiction, and even counsel uses the word insidious, and it is. It is detrimental to you individually, the way you view the world, the way you interact with others in the community, and it disrupts so many things in your life. I note that you were abused significantly in your life physically, and there's a great deal of experience and literature and professionals that comment about that kind of effect on children when they are abused. And here you are today. You use the language that this porn was your drug, and ultimately you became bored with adult porn. And once again, this is something that needs attention over the course of your life. Most everything that this court has been exposed to in terms of experience and literature and professional training acknowledges that the pleasure centers that exist in the brain are similar and identical in many instances to other addictions, and that is why there is a long-term ongoing need for attention with these things, as the brain has been affected by this pornography. And it's your language, it's not mine, to suggest that you became bored with it, and that's something that the court has seen over and over and over again, and that you became desensitized over the course of time. I do find it striking and notable that in and among your comments you indicated that you would never hurt a child because you had been that child. That struck me. And I accept today your statement about the victims associated with your actions, and I think you've likely even grown from the time in which you made this statement in the pre-sentence report and your comments today. Everyone in this courtroom would understand that there are victims associated with this case, and you directly and indirectly in one way or another participated in harm to those individuals. You helped provide a market for this kind of thing. And what strikes the court as well is that when I invited counsel to share with the court whether there would be any witnesses, and you had your appropriate witness, and in so many offenses, there are victims that come into this courtroom and make statements, and there are none today. But it doesn't mean that there are no victims. There are victims, and it's sad to me that their voice is only heard today through the parties and the acknowledgement and the state's representation. After I read your letter, very thoughtful letter, I was left sick with the trauma that you have endured. And it's the same emotion I want you to recognize that I feel when I read about your addiction and the offenses that are involved with this case. It's the very same sick feeling that I am left with. And so all of these things become important, and acknowledgement again for those mitigating facts because of this court's view that there will be an ongoing need for attention related to the way you have altered your brain by viewing child pornography and the addiction associated with it. I will follow the state's recommendation. Had they not modified their recommendation, I would have imposed the 3 fixed, but they see, like this court does independently, a number of good things, and as a result, I will impose a fixed sentence on count 1. As I recall, the counsel, was it counts 1 and 2 that were pled to, or were there other counts? It looks like under the terms.
Just the 2, Your Honor. The rest are dismissed.
Counts 1 and 2. So count 1 will be a 2-year fixed with an 8-year indeterminate. Count 2 would be a 0-year fixed with a 5-year indeterminate. These counts would run consecutive to one another, and so ultimately there would be a 2-year fixed followed by a 14-year indeterminate sentence. The court imposes a $1,000 fine on each of the 2 counts. Court costs and the Victims Relief Fund are standard, and that will be the reimbursement of the services of the public defender in the amount of $400. You have the right to appeal this judgment within 42 days. Post-conviction relief expires a year after that, and a Rule 35 expires in 120 days. Mr. Demaria, do you have any questions?
I do not, sir.
Okay, thank you. And on this matter, we will be in recess.